Hello, everyone, and welcome to ACS Webinars, connecting you with the best and brightest minds in chemistry, live from Washington, D.C. I'm Michael David, and I am pleased to be your host for today's broadcast, which is being co-produced with ACS industry member programs, ACS President H.N. Chang, the ACS Board Committee on Corporation Associates, the ACS Committee on Technician Affairs, the ACS Division of Small Chemical Businesses, and the ACS Division of Business Development and Management. Today, we are continuing our series on how to start a business with a look at the basics of IP, patents, and what you need to know when getting started. We are joined by Ken Sibley, who is the Assistant General Counsel and Patents and IP at Carbon. He has been a patent lawyer since 1985, focusing on patent preparation and prosecution for our entrepreneurial startup, university, and multinational national corporate clients, with a primary emphasis on chemical and biomedical technology. We would love to get you involved in the discussion, and you can share your thoughts and questions in the questions panel. You can also join the discussion on Twitter by including @AmericChem Society in your tweet. The slides for today's webinar can be accessed right now by clicking on the link you see in the GoToWebinar control panel. An invitation email to view the recording from today's presentation will be sent to all registrants in a few hours, and that recording will stay open for a 24-hour period, after which it will be removed, edited, and added to the ACS Webinars library. Our moderator for today is Jim Skinner, the President and CEO of Terragena and Chair of the ACS Division of Small Chemical Businesses. He is a consultant and contractor with the Federal Economic Development Agency of the Canadian federal government and has been an adjunct professor in the College of Business at Western Carolina University. To introduce the broadcast today, I will turn it over to the President of the American Chemical Society, H.N. Chang. Prior to serving as president, he served on and chaired several ACS committee and task forces at the national level, and has been active in various capacities in local sections and technical divisions, and has been a member since 1982. H.N. is a research chemist at the U.S. Department of Agriculture. Previously, he worked for many years at Hercules Incorporated, where he held various R&D and managerial positions. And with that, H.N., I will turn it over to you.
Well, thanks, Mike. It's a pleasure to be in this webinar with all of you today. As ACS President, my platform is growth, collaboration, and advocacy. As we know, chemistry is a wonderful profession, but we need to grow and strengthen the global chemistry enterprise in order to remain successful. Some possible areas of growth includes innovation, entrepreneurship and industrial engagement, sustainability and new frontiers, international collaboration, and continued public and government support. From history, we know that innovation is the engine of growth for any civilization and society. Most of us doing research and development are involved with innovation and discovery. The key is to translate these innovations and discoveries from bench to market. This requires entrepreneurial and business skills not usually taught in graduate schools. What we need is to have an educational program to train more chemists and chemical engineers on entrepreneurship and business management. In this way, we can stimulate innovation, promote new enterprises, recruit and retain members who see innovation and management as integral to their professional goals. These are the reasons for having these webinars, which is the result of the collaboration among ACS industrial member programs, ACS webinar team, ACS divisions of small chemical businesses and business development and management, corporation associates, and the Committee on Technician Affairs. Last year, we have had 2 ACS webinars on how to produce a business plan and how to get funding for your new business. You can still have access to the recordings of these 2 wonderful webinars through the ACS webinar website, as shown on the left in the slide. Now, this year, we have planned 3 more webinars on entrepreneurship. On the slide, on the right side of the slide, as you can see here, these include a sole proprietorship to incorporation on July 21st, intellectual property today, and how to organize a new firm on August 11th. I would like to thank Jim Skinner, the chair of ACS Small Chemical Businesses Division, for its critical role in organizing these webinars. It's our hope that these webinars will be beneficial to you as you engage in entrepreneurial or management activities in the future. Now I'll turn over to Ken.
Thank you, HN. And hopefully, do we have my opening screen up?
Yep, we're right where we should be.
Okay, thank you very much. And thank you, HN and Jim, for inviting me. So to start off, before we launch into patents and intellectual property, let me tell you a little bit about Carbon. I think this might be a useful case study of a startup company and intellectual property. And my involvement with Carbon started in February 2013 when a longtime client, Joe DeSimone, gave me a call and asked me to come over and start working on Carbon's first provisional patent application filing. So we did that in 2013, me working as outside counsel. And for the rest of that year, that provisional application was updated. Carbon got some angel funding. Carbon got venture funding. It went from a startup of 4 individuals, Joe, a professor at UNC Chapel Hill, Ed Samolsky, also a professor at UNC Chapel Hill, some of you may know, and 2 others, to, by March of 2015, about 40 or 50 people. In March of 2015, Carbon came out with its very first publications and public disclosures with a article that was the cover article on that issue of Science. And on that same day, a TED Talk that Joe gave up in Vancouver, I believe, with Carbon's prototype 3D printer running in the background. Later in 2015, Carbon's first 3 United States patents issued, all in December. Those patents were based on a, as you can see down in the bottom left corner, they were based on a series of provisional patent applications filed in 2013 and 2013, and then a patent cooperation treaty application filed in 2014, from which the US applications were then filed. And we'll talk more about that. Since that time, let's see, I joined Carbon as inside full-time patent counsel in September of 2016. Carbon has grown from those 4 employees, 4 original founders, to more than 400 today. Our CEO is Ellen Coleman. Our CEO had been Joe DeSimone, and the torch was passed to Ellen Coleman. Some of you may recall her time as CEO of DuPont. She had been on our board of directors for several years. We've grown to 400 or more employees, spanning a variety of disciplines, on the R&D side, mechanical and electrical engineering, and those teams, the hardware teams, have developed a series of devices, equipment, our M2 or medium-sized printer, our L1 or large printer, that's what the Adidas midsole is printed with, some related equipment, complementary equipment, such as a part washing machine, and those developments are ongoing. After the basic innovations in the printer process and apparatus were made, Jason Rowland, previously a postdoc in Joe's lab, joined our team. He's currently a senior VP of materials at Carbon, but Jason and his team have developed a series of resins, particularly dual cure resins, where the shape of the object is imparted by light polymerization in the 3D printing apparatus. But then there's an additional curing system or polymerization system that in the printed part, once it's removed from the machine, is polymerized by baking to impart the final mechanical and tensile properties that are needed for whatever application the part is intended. And those properties can range from rigid, temperature, heat resistant, and impact resistant to flexible parts to elastic and high energy return objects. And in the course of all this, Carbon realized that lattice type 3D printed parts were particularly suited to our systems and our resins. Complicated lattice parts require some considerable ingenuity to create. We have a team of computational mathematicians led by Dr. Hardik Kabaria from Stanford. Got his PhD not too long ago from Stanford, and others, and associated software engineers. The lattice design software or design engine that we use has helped develop the set of pads that are glued together in this example, if my cursor is working. The Rydell football helmet, that's obviously the liner of the helmet, more than a dozen pads glued together. This is the graphic rendering of a bicycle saddle, but the actual saddles are commercialized by Specialized and Physique. And they get quite good reviews. And during the early phases of the COVID crisis, when you may recall flux swabs that are made primarily in Italy became unavailable, flux swabs being what was used in nasopharyngeal testing at the time. When they became unavailable, Carbon and others sought to rapidly develop 3D printed swabs, and we were able to iterate through very quickly a series of 3D printed elastic swab designs for COVID purposes. Just a little show and tell. This would be an example of the Adidas midsole, and these are commercialized, available in commercialized shoes. And another example, it's not a strut-based lattice, but a minimal surface lattice. Again, with those elastic and energy returning properties, not something that was easily produced by 3D printing previously. I mentioned we have an extensive materials team, so I have to give them credit for their work, interest in work in green chemistry, not only with just minimizing waste streams, but in developing chemical systems that are themselves useful for recycling. And that work, some of that work was presented last year right here through ACS. And I see this takes us to a first poll question. Mike, I'm going to pass this back to you.
All right, our first poll question is, all of the following are inventors on at least one US patent, but which one has the most? Apologies, I shared the wrong poll there. Was it Haim Weizmann, Carl Ziegler, Giulio Natta, Wallace Carruthers, or Jennifer Doudna? And to answer, you can simply click on one of the white buttons on your screen to let us know which one you think has the most patents. And while you're doing that, I want to remind you that we are eager to get your questions for the Q&A session after the presentation. So don't hesitate to ask when they come to your mind. And with that, I'm going to close this poll in 5, 4, 3, 2, 1. And it looks like we had 13% for Dr. Weizmann, 30% for Dr. Ziegler, 9% for Dr. Natta, 27%, which was the largest for Dr. Carruthers, and 21% for Dr. Doudna. And with that, I will turn it back over to you, Ken.
Okay. Thank you, Mike. Well, that's pretty good, pretty accurate. Dr. Doudna has only one so far, but of course, she's still very active. Dr. Carruthers, as best I can tell, and it's a bit difficult pulling out numbers for some of these pre-1970 patents, but was on the order of 20, but certainly 20 to 40. Dr. Wiseman, probably best known for the patent on his work for the production of acetone from maize with Clostridium acetobutylicum. That work attracted the attention of Winston Churchill, First Lord of the Admiralty during World War I, who had a need of acetone for making cordite. Of course, it wasn't the patent that attracted his interest, but the patent became important otherwise. And of course, that's not President Wiseman's greatest claim to fame. I think probably the leaders are Carl Ziegler and Julio Nata, and it was Julio Nata that is probably in the lead with on the order of 120. So with that, let's go on and talk more about intellectual property. And I'm primarily a patent attorney, so I'm going to give the greatest emphasis to patents, although let's not completely ignore other areas. They are trade secret, trademark, copyright. Depending on the technology, some of these can be very important. Depending on the technology, patents may not be available. But for a lot of the chemistry and biotech and medical device space, patents are considered the premier form of protection. And it's also the form of protection with the greatest number of pitfalls. There is a lot of lingo in the patent space, and I'm going to go through some of that here. It may not all make sense at this point. Let me touch on it. Bear with me. We'll come back and describe some of these in actual use. But I wanted to have a slide here just to so in the handouts they would be available to you. So let me call, since this is a chemistry group, let me call them precursor applications. These I think of as United States provisional applications. I'm sure many of you have heard of those. Patent Cooperation Treaty, or PCT applications. European Patent Office applications, or EPO applications. None of these become issued patents themselves, but they're precursors or intermediates on the way to a issued patent. From any of these, a regular application needs to be filed. A regular, or sometimes called national stage application, could be for any of a variety of categories of things. It could be on a method of making or synthesizing. It could be on an apparatus or device. Certainly Carbon's 3D printing processes are covered by these, or these type of patents. It could be on a novel compound per se, as common in the pharmaceutical industry. It could be on a composition or a complicated mixture of compounds, as is common in the polymer science and resins industries. That one patent has issued on a particular thing does not preclude future improvements from being patented. So you will hear the term improvement inventions, but that kind of overlays with the other terms. I should mention there are various other types of patents: design applications, plant patents, plant variety protection certificates, utility models, only available for apparatus, becoming important in China, but not something available in the United States. But of these are the ones we're going to talk about the most. Another way of looking at and describing patents, just so we have this terminology out, and again, just so you have a place to refer back to, is to refer to patent families. One provisional application or chain of provisional applications might give rise to a family of patents. It might give rise to an issued US patent. It may give rise to related, same text, foreign counterpart applications. The scope of those foreign counterpart applications may differ from the scope of the US patent due to differences in laws between US, Europe, Japan, China, and so forth, wherever the foreign counterpart is being examined. And as is common in the United States, there may be a progeny application. Sometimes these are called parent, grandparent, or related as parent, grandparent, great-grandparent, or parent, child, grandchild. And this occurs when an application is allowed in the United States, and just before it passes to issuance of as a granted patent, a continuation or divisional application is filed in the US Patent Office to pursue additional or alternate claims. I'm sure many of you are familiar with the term claims in patent speak. That is the sentences at the end of a patent that are the formal definition of the scope of the patent. And there are many patent families with multiple members where, of course, the drawings, the figures, the text all looks the same, but the claims can differ dramatically. So progeny applications, parent, grandparent, continuation, divisional, all very important in United States patent, but that's a terminology that overlays on this terminology. So with that, I want to go into 3 areas that I would emphasize as best practices for implementing patent programs. To just state these up front, I want to emphasize the importance of distinguishing patentability from freedom to operate. I want to spend most of my time talking about the patent filing timeline, because initial filings of patents can be somewhat expensive, but the greater expenses occur downstream from initial filing, and the initial filing can lock you into a schedule for those downstream events that may or may not be good for you. And finally, I want to speak briefly about the importance of a patent committee. So, patentability from freedom to operate. It is fundamental in U.S. patent law, and indeed patent laws around the world, that the fact that you can get a patent on something does not necessarily give you freedom to operate or the ability to commercialize what you have patented. Your commercial product could be blocked by a still active or earlier dominating patent held by another party. So that raises a question of should you search for blocking patents or not? And if so, how much should you search? And how often should you search? A search done one year might not be applicable the following year as old patents expire and new patents issue, or as the product changes as it's developed towards commercialization. There are widely different opinions on this, ranging from never search at all to search constantly and exhaustively, which can frankly get very expensive. And if the searching does not create expense, then the associated legal opinions for discussing why a particular patent uncovered in a search isn't a problem could get expensive. So I can tell you that potential investors may ask you whether or not you have searched, or they may do their own searching and then ask you about the results that they have found, which can be an uncomfortable situation. There are no general rules for this, and as I've said, there's widely different opinions, and these different opinions held by influential folks. So this is simply something to discuss early with your patent counsel and decide what is best for you. You will sometimes hear the expressions landscape search. I generally call that an initial look, or a look for any obvious problems before entering a field, versus a much more focused freedom to operate search on a particular very specific product. Oh, okay. We're at another survey question. Back to you, Mike.
All right, our second question for all of you is, which Nobel Prize recipient is also the inventor on dozens of patents? Would it be Francis H. Arnold, Thomas R. Cech, Glenn T. Seaborg, Irving Langmuir, or all of the above? And you can again click on the response that you think is the most correct. And just a reminder, we are still accepting the questions, seeing a few come in, but we do have room for more. And with that, I'm going to close this poll in 5, 4, 3, 2, 1. All right, and 6% said Dr. Arnold, 3% said Dr. Cech, 3% said Dr. Seaborg, 40% said Langmuir, Dr. Langmuir, and 49% said all of the above. So with that, I will turn it back over to you, Ken.
I think that's pretty good. Of them all, I do believe Dr. Langmuir was the most prolific, but the correct answer in this case is all of the above. And thank you, Mike. So now let's talk about the patent filing timeline. And here in the United States, that almost universally as a best practice by large companies and small, begins with the filing, excuse me, of a provisional application. Provisional applications were created when U.S. excuse me, when U.S. patent law was changed to a 20-year patent term from file. Well, it was quickly noticed that foreign applicants had the ability to file in their country, wait 1 year to file in the United States under the Paris Convention, and upon U.S. filing, then have a 20-year term, which seemed to give ex-U.S. applicants 21 years compared to U.S. applicants. So the provisional application was specifically created to give U.S. patent applicants term parity with foreign applicants coming into the United States. It was not created as a placeholder or low-cost application, and this has an important implication, which we'll get to in a later slide. From a first provisional filing, a provisional filing has a lifespan of 12 months. By the end of that 12-month period, a decision or a step must be taken to, hopefully the decision is taken well before the deadline for the step. A step must be taken to either abandon U.S. only file or cooperation treaty file that provisional application. If it's U.S. only filed, that application will publish 18 months from the earliest date, and then examination of the U.S. application will continue, hopefully towards issuance of a patent. Now, U.S. only filing does not preserve any rights outside the United States. And for many fields, rights above and beyond those in the United States are important. So one approach is to, when we reach that first branch point, decision point, is to not only U.S. file the application, but to, in addition, file the application under the Patent Cooperation Treaty. And many patent applications are first become publicly available as the published PCT applications, which publish on the same time schedule as the U.S. application. A PCT application, as I said previously, is a precursor or an intermediate. It never issues as a patent, but it does give you time, in this case, 30 months from the original filing date of the first provisional application, to make a decision whether you want to incur the very considerable additional expenses of filing in, for example, European Patent Office. That's usually my first choice. And then additional foreign countries, common choices being Japan, China, possibly from the United States, Canada, Australia, Korea. And a slight variation on that time frame, that I like is here you see I've skipped or delayed the U.S. Filing step since the U.S. is a member of the Patent Cooperation Treaty as well, is to begin the U.S. filing along with and about the same time as the European Patent Office filing. This does not save any fees, but it just moves the U.S. fee from that 12-month point to the 30-month point. Okay. I want to emphasize a common misconception that is very dangerous, that a quick and dirty or cover sheet or simplified provisional filing can be done as a cost-saving device. And then 12 months later, a more thorough US and or PCT filing done that the attorney can be engaged at that point and then proceed with examination. The problem with this is that if there is any intervening disclosure between that cover sheet filing, sometimes called a cover sheet because it simply involves attaching the USPTO formal papers to an invention disclosure form that the inventor has written. If there is any intervening disclosure, whether by you or by a third party, between that cover sheet filing and the more thorough filing, then several years and substantial money invested later, when the application is examined, the examiner will say, hey, wait a minute, what you're claiming now, I don't find in your original filing. I find it only in your later filing, but there was a disclosure before that, and therefore you are rejected over that intervening disclosure. Now, the precise details of this will vary depending on whether you're in the United States Patent Office being examined or a foreign patent office, but I've seen many painful results from this. And finally, I should very much emphasize there are some key windows in these time filings. I mentioned that Carbon, like many companies, did its PCT filing from a chain of provisional filings. And hey, in most of our fields, a lot can happen in the first 12 months. And that first provisional filing can be updated with new data, new thoughts, new features, new ideas. I've sometimes said this is the most inexpensive, cost-effective, valuable thing a patent counsel can do for their client. So that's the first key window, updating the provisional filing. Second key window is before the PCT application publishes. This assumes there's no intervening publication, but if there's a new related innovation, up to the time that PCT application publishes, that's an ideal point for filing a new related application. So a lot of decisions to be made here, decision points, US only or PCT, what foreign countries to file in, when to update provisionals, when to file new applications. Who makes these decisions? Here's a summary of what I just said. Who makes these decisions? Well, I'd suggest create a patent committee. And even a small startup company can have one. Now, this assumes you get to the size of 10 or so. But these decisions are not strictly legal decisions. And it's important on each of these steps to have a distinct research and development perspective, legal perspective. One of the functions of the PCT is not to defer costs, but to get some early feedback on patentability. Business perspective. Is this going to cover a product we feel we're going to develop? How important is this to the product we're going to develop? In what countries is this relevant to our product? And And of course, financial perspectives. Can we afford to take this step? Or where should we make our best investments? A committee like this can meet 4 to 6 times a year. It should include senior management. And I've seen potential investors extremely impressed that even small companies have a patent committee. So if I were to leave you with best practices, distinguish patentability from freedom to operate, understand the patent filing timeline, and early in the company's existence, create a patent committee. For more about patents, your university library probably has considerable material. Tech transfer offices will have considerable materials. I'd suggest the USPTO website, the World Intellectual Property Organization website, the European Patent Office website. There's other websites as well. If you're interested for more about Carbon, you can certainly see our website. We have, in addition to our broad websites, one devoted to technical publications and another devoted to our patent holdings. And with that, Mike or Jim, let me turn it back to you.
Ken, thank you very much. Very, very insightful perspective on patents and what they can and cannot do for you. I'm just going to take a half a second to make an unabashed advertisement for the Small Chemical Businesses Division of ACS and our role in helping people who are interested in growing a company, building a business. We have a team of people and many members who are here to help in any way that we possibly can relative to your questions regarding entrepreneurship and innovation. I'd also like to note that we at SCHB have a weekly Discuss Business happy hour and also a series of meetings called Continuing the Conversation, which we will do this afternoon at 6 p.m. Eastern Time, 3 hours after this broadcast, to continue the discussion on this particular topic and other related business topics. So if any of you would like to join that conversation later, email pr@acs-schb.org and you'll be invited to our virtual happy hour Discuss Business. And after that unabashed plug, I would like to turn to the questions that we have. And one of the first questions I'd like to ask, Ken, is what is the difference between trade secrets for those of us who want to use trade secrets versus patenting? How are they handled in a small company versus possibly the same situation in a larger startup or in big companies?
Okay. Well, my experience with trade secrets can be very valuable. It's kind of the other side of the coin, the opposite approach of a patent. A patent would disclose, for the most part, your trade secrets, at least as far as they're known at the time of the patent filing. Many companies will file as early as they can on a patent to obtain a patent, but developments after the patent filing can then be held trade secret. For a small company, a couple founders, less than 10 at the very early stages. My experience is people pretty much know their responsibilities to keep things secret from outsiders. It's as companies grow that securing trade secret becomes more of a problem and requires more of a formal effort. And there's lots and lots of publications and websites that would talk about the checklists and steps that a company should go through to maintain trade secrets. Limited access to doors, limited access to certain materials, no cameras on presence, employment agreements, confidentiality agreements. There's checklists for these things. I think the trick for a small or growing company is knowing when to transition from one to the other. And for that, I'd say just get some advice early on before there's a trade secret leak from a lawyer. It's the type of thing. It's not that hard to set up the program in advance, but once the cat's out of the bag, it's a big problem.
Good point. One of the folks in the audience wants to know if I sponsor research at a university, who owns the IP and possible patents and patent rights?
Yeah, I think that's going to, weren't we chatting about this earlier? You pointed out it depends on the country. And it depends on the university, and it depends on the agreement with that university. All the universities here in the Research Triangle area have a Office of Sponsored Research, and many of them have form and template agreements available, and you can go and download their template agreements and get a feel for what a particular university is willing to accept. But it simply varies widely from university to university, and even lab to lab. It might depend on what other agreements and entanglements and federal sponsorship a particular lab has. So, conversation to have with the Office of Sponsored Research early on.
Okay. Another question. To what extent can a product in the pre-application process be protected?
I'm not sure what a pre-application means there. Does that mean pre-patent application process? I mean, if we're talking about protecting a product pre-patent application, then one just needs to be really rigorous about trade secrecy. If it's talking about sharing a product idea with a company or a third party before an application has even been filed, then at minimum, a confidentiality or non-disclosure agreement is necessary, and a lot of companies won't sign those. So there is if that's what pre-application means in that case, I think trade secrecy and rigorous trade secrecy is all that's available.
Okay, as an extension of that, a lot of small companies are starting at the university, and they are in the process of filing their provisional, and at the same time they're raising funds or attempting to raise funds to move their idea into commercialization, or at least the various steps relative to getting the funding to complete the R&D and move to commercialization. But a lot of, I think you just mentioned, a lot of potential corporate partners and or funding sources such as venture capitalists are reluctant to sign confidentiality agreements as a result of the vast amount of technology to which they're exposed. What's your advice to that small company that is trying to raise funds, but a CDA is not possible between the small company and the potential funding source?
If the patent application or applications have been filed and they've been fleshed out with the knowledge that a non-confidential disclosures about to be made. That's one step to take. Another step is to only share with trustworthy, reputable sources. Know who you're going to be talking to. And finally, there may be an opportunity for defensive publication. That's filing your patent application and then publishing what you have filed even before the patent office might have published it, just to prevent competitors from making obvious improvements over what's in your patent filing. But defensive publication is something you probably need to talk to your patent lawyer about your specific case.
Okay. Question here asks, how do you balance between marketing technology and starting a company and the conflict of interest in publications?
Yeah, that's particularly problematic for the university startup. There is that pressure to publish. It may be a responsibility to graduate students. It may be just part of the important professional development of the inventor, and or it may be necessary to, as you point out, raise the capital needed to take the company forward. And there's just not easy answers to that. It is without doubt an advantage to the company who's able to do their patent filing and reinforce their patent filing with additional patent filings for a year or 18 months from that original filing. There is just no getting around the significant advantages that offers. Some companies refer to that as being in, some startups refer to that as being in stealth mode, I think is the trendy new term for that. But yeah, you are forced to give up some of those advantages and say, again, have a trusted patent counsel, somebody you have a long-term relationship with. Now, Joe DeSimone tells a story that to others when recounting how he and I started working together on Carbon. He'll said, "Oh, I talked to Ken about writing a patent application. I told him we didn't know how we were going to pay him for it, and Ken said not to worry." Now, I've said to people on hearing that story that I don't remember it exactly that way. But I probably said, I'm not worried, because I wasn't. This was a long-time trusted client, and I had a lot of faith in him. And I think having that kind of partnership relationship with a long-term patent counsel is really helpful.
Excellent. Speaking of university-based research that results in discoveries that could possibly be commercialized, what's your recommendation to folks, university-based or elsewhere, with respect to record keeping for patent purposes?
Oh, yeah, keep good records. And there's been a lot. There's a lot written on record keeping. Let's see, I have an old book. Here's one I've recommended many, many times over the years. I think it's out of print now. It was Howard Kanner, Writing the Laboratory Notebook. It was an American Chemical Society publication. And for a while, I was buying many copies of these secondhand and passing them out to clients. But, I'd first say keep the same good records that you'd keep for any scientific endeavor. I mean, even if you weren't involved with patents at all, there's many reasons to be keeping good quality, detailed laboratory records. So that would be my very first recommendation. Keep good records as you would for any research project, whether or not you were involved in patents. Beyond that, patent-specific advice, it's sometimes useful to write down ideas. Some people keep an idea notebook separately from their laboratory notebook. Some people put down ideas in their laboratory notebook. Unique in patents is the importance of having the laboratory notebook, quote, witnessed by somebody who is not an inventor. There's some pre-printed, there used to be pre-printed laboratory notebooks that do this. And now there's software. I'm not prepared to go through all the software application, software products available for this, but there are software products available now. And just put the time and effort into keeping good records.
Okay, excellent. Thank you. Kind of an interesting question. How much time needs to pass in order to make a product according to the patent without legal repercussions?
Oh, well, you need to wait for the patent to expire. Most active U.S. patents now are 20 years from, have a term of 20 years from filing. So that would be the initial rule of thumb. If you look up a patent may expire because a maintenance fee has not been paid. If you look up the patent number on Google Patents, they will give you an estimated expiration date, and they will give you a indication on whether the patent has expired for lack of payment of a maintenance fee. I wouldn't use Google as the final word, but I'd certainly use it as a starting point. Google Patents. If I was going to rely on something, then I'd confirm it through the official U.S. Patent Office records. But those would be the way to go about it.
Okay. Kind of going back to a previous question, this whole issue of disclosure of information relative to funding, and this person is asking, how can one obtain investor funding if disclosures disqualify patent approval? I guess the corollary to that is, should funding only be pursued after obtaining a patent protection?
Well, I would say best to get the initial applications on file before going forward with the to pursue the funding. And in the case of carbon, and this is all public record, we have 70 or more issued United States patents at this point. Not all of them, less than half, probably less than a quarter of those were filed before the initial funding was secured. But the initial patents were filed before that initial funding was secured. And you will hear in as follow-up rounds of venture capital funding is sought, it's common for folks to hear questions like, how wide is your moat? Have you, since that last round of funding, pursued additional filings?
Okay. To give folks an idea, because in so many cases, there is, and you pointed it out during the presentation, there is the initial cost of beginning the patent filing process. And maybe you can give an indication of what, generally speaking, a person would be looking at for that initial, that cost of that initial work. But then as the clock ticks onward, decisions have to be made. And if the decisions are to move forward with the the patent application after the filing of the provisional, and there's filing in the US, in Europe and other countries. How do those numbers begin to move out, and sort of what is the time frame for budgeting, if you like, for a person or a startup company in terms of this is what it's going to cost me now, but in 12 months, I'm now going to be looking at numbers that are in this other range. Can you give us an idea of what those might be?
Yeah, I can. Let me state some numbers. These are going to vary from country to country and region to within the United States. They vary from region to region. They will vary depending on the level of experience of the inventors. Can they give the patent attorney what they need in a reasonably straightforward way? It will vary depending on the experience of the patent attorney with this particular inventor. It's one thing to start cold with a patent attorney, to start cold with a brand new inventor. It's another thing to work with somebody that you have familiarity and experience with. So, that said, just to put some specific stakes in the ground, initial provisional filing might be $5,000, attorney's fees, government expenses. A supplement of that provisional filing along the way might be $2,000 or $3,000 during that first year. The PCT filing, one might budget $5,000 to $10,000 to put it on file. I'm kind of assuming there's going to be some formalization of figures and drawings. There are some shortcuts that can be taken at the provisional stage, but one needs to be careful about that. So there may be some redrafting at the PCT stage. So let's say 5,000 to 10,000 there. But then I think that 18-month lifespan of the PCT application, one needs to allow another $5,000 to $10,000. It may happen that you get an initial search report from the PCT examiner saying, 2 thumbs up, in which case, great, you're done. It may be that you get a rejection that you completely disagree with, and you have the choice of whether or not you want to argue with the PCT examiner. I like to sometimes, but it's not required, or you could argue only part of it. So one needs to, I think, set aside another 5 to 10 at that stage. Then that pushes us out to the 30-month point. And there it's, if you're coming into the US, I'd say 5,000 for the first step, 10,000 for Europe, 10,000 for Japan, 10,000 for China, maybe 5,000 for Canada or some other countries, if they're English language countries that don't require translation. But then when you've taken that step, you've also engaged law firms in each of the foreign countries, and you need to be prepared for back and forth with those firms from their respective patent offices, and all of those will have costs. So you really are launching into a significant expense at that point. And that's just for one application. You're going to have, hopefully, overlapping applications.
So it is obviously critically important for a person or a startup company to really understand not only the step that you take in terms of filing your first provisional, but what that's going to look like down the road in the months and the couple of years ahead. In that respect, and this will be my last question for you, is what about people who take a look at the internet and said, hey, I can do this myself? What do you think of the DIY approach to patent filings?
Well, some people point out that a patent is the first document you file in a patent lawsuit, the patent application. Look at patent litigation. It is, if a patent is litigated, it is a multi-million-dollar a year, multi-year expense with, in legal circles, patent litigation is somewhat pretentiously referred to as the sport of kings. It is that high stakes, and it attracts that level of talent. So there are more than a dozen ways a patent can be invalidated. Patents can be designed around. I think the old rule of thumb on training new patent attorneys is until they've done 30 patent applications, they're really not able to, and gone back and forth with the patent office negotiating those 30. They're really not don't have experience to do it on their own. So I think DIY for the beginner is just not a viable approach.
Okay, thank you. That good advice in terms of protecting the discoveries and the inventions that you've made. Ken, just before we close off, do you have any closing thoughts for the folks?
Yeah, I would say what I've enjoyed most in my career since 1985, and where I felt I have been most cost effective for my clients is where I've had a partnership relationship with the client. It's the relationship with the attorney should not be an adversarial relationship. It should not be a service provider type relationship. If you can find the right person and establish that type of relationship, I think that would serve you well.
Excellent. Ken, thanks so much for being here and helping all of us understand patents and intellectual property so much better. Mike, I turn it back to you.
All right, well, I'd also like to thank both of you for joining us today and sharing your wisdom with us. Just a reminder that we do have one more broadcast in the series coming up on August 11th on how to organize your new firm. So make sure and go to acs.org/webinars to register for that one. I would also like to let you know about a few webinars we have coming up before then. Tomorrow, we will be joined by Punit Seth, the Vice President of Medicinal Chemistry at Ionis Pharmaceuticals, as he discusses the general principles for delivery of RNA-targeted oligonucleotide drugs. On Wednesday, August 4th, we will be joined by a panel of industry experts who will share what industry can do to encourage young people from underrepresented populations pursue a STEM education. Finally, on Thursday, August 5th, Patricia Simpson will be returning to share how you can build your business acumen in order to be recognized, valued, and respected within an organization by thinking like a CEO. We would love to hear what you think about our program, and you can always reach out to us on the ACS social media channels on Facebook, Twitter, LinkedIn, or simply email us at acswebinars@acs.org. Of course, we are curious to hear what you thought of today's broadcast, and a short survey will pop up directly after the webinar that will take just a minute to complete. Also, remember that an invitation email to view the recording of today's presentation will be sent to everyone. This recording will be open for a 24-hour period, after which it will be removed, edited, and added to the ACS Webinars library. And that wraps up our program for today. On behalf of all of us here at ACS, thank you so much for joining us, and we hope to see you again soon.